If you saw a headline claiming that a March 2026 High Court decision just made 8 types of specialized hardware illegal in your state, I need to tell you something right now. That headline is wrong. There is no March 2026 High Court ruling that banned any hardware. But here's what makes this dangerous. The truth is actually more complicated than that headline. And if you don't understand what's really happening with hardware restrictions in the country right now, you could end up on the wrong side of the law without even knowing it. Are you subscribed? Because what I'm about to explain is the real situation with restricted hardware bans in 2026. And 90% of owners are getting their information from viral headlines that are completely misleading. Hit subscribe now so you get the facts, not the fiction. Let me start by clearing up what did not happen. There was no High Court decision in March 2026 that made any hardware illegal nationwide. That's fiction. The High Court has not issued any ruling in 2026 that banned specific equipment. What actually happened is very different, and you need to understand it. Here's the real timeline. In June 2025, the High Court declined to hear 2 major cases. The first was a challenge to a regional ban on specific semi-automatic hardware. The second was a challenge to a regional law regarding accessory capacity. When the High Court declines to hear a case, that's called denying a petition for review. And what it means is simple. The lower court ruling stands. It does not mean the High Court agrees with the ruling. It does not mean the High Court has made a decision on the merits. It just means they're not taking the case right now. So when the court declined review in those 2 cases in June 2025, the effect was that the regional hardware ban stayed in place and the accessory ban stayed in place. Those local laws were already on the books. They didn't become illegal because of a High Court ruling. They stayed legal because the High Court declined to review them. Now here's what did happen in March 2026 that might be confusing people. In a case called Benson versus United States, the District of Columbia Court of Appeals struck down the district's ban on accessories holding more than 10 rounds. That's a local appeals court decision, not a High Court decision. And it went the opposite direction of the headlines. It struck down a restriction. It did not uphold one. The Benson decision is important because it creates what's called a legal split between different regions. Some courts are upholding these capacity limits. Other courts are striking them down as unconstitutional. When there's a split like this, it increases the chances that the High Court will eventually take up the issue to provide a single national rule. But as of now, the High Court has not ruled. So let me be crystal clear. If you live in a state with a hardware ban or a capacity restriction, that law is still in effect. If you live in a state without those bans, nothing has changed for you either. There is no new nationwide rule from the High Court. The laws vary by state just like they did before. If you're finding this helpful, imagine what you'll learn in my next video where I explain the exact legal test the High Court will use when it finally does rule on these hardware bans. Subscribe now so you don't miss it. Now let me explain what hardware is actually banned in certain states right now. Because even though there's no March 2026 High Court ruling, there are state laws that have been on the books for years. And if you live in one of those states, you need to know what's prohibited. 10 states currently have hardware bans. California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, and Washington. Plus the District of Columbia. Each state defines restricted hardware differently. This is critical. There's no universal definition. Each state legislature wrote its own law with its own list of banned features and banned models. But there are patterns. Most of these laws ban equipment based on a combination of features. Let me walk you through the typical features that trigger a ban. For semi-automatic items, the common banned features include a grip that protrudes beneath the action, a thumbhole stock, a folding or telescoping stock, an integrated launcher, a barrel shroud, and a threaded barrel designed to accommodate a flash hider or specialized attachment. If a semi-automatic item has certain combinations of these features, it gets classified as restricted hardware under state law and becomes illegal to possess. For semi-automatic items, restricted features typically include a threaded barrel, a second hand grip, a barrel shroud, the capacity to accept a detachable accessory at a location outside of the primary grip, and a semi-automatic version of a restricted rapid-fire item. Again, it's the combination of features that matters. For semi-automatic smoothbore items, restricted features include a folding or telescoping stock, a primary grip, a fixed accessory capacity exceeding a certain number, and the ability to accept a detachable accessory. Now here's where it gets tricky. Some states also ban specific items by name. One prominent state's law, for example, specifically lists dozens of models by manufacturer and series. The most common modern sporting platforms, certain imported series in all forms, and many others are on the list. If your item is on that list, it's restricted. Period. Even if it doesn't have the features that would otherwise classify it as restricted hardware. Other states use a more generic approach. They ban any semi-automatic rifle that can accept a detachable accessory and has one or more of the prohibited features. This means the list of restricted items is theoretically unlimited. Any manufacturer could make a piece of hardware that fits the definition, and it would automatically be restricted in that state. Let me give you 8 specific examples of hardware that are restricted in multiple states right now, not because of a March 2026 High Court ruling, but because of regional laws that have been in effect for years. Number 1, modern sporting rifles in the standard configuration. This includes any semi-automatic rifle chambered in common calibers that has a primary grip, collapsible stock, and threaded barrel. This is the most popular style of rifle in the country. Millions are in circulation, but in the 10 restricted states, possessing one manufactured after the effective date is a serious violation. Some states grandfathered in items owned before the restriction. Others require formal registration. Others require you to modify the item to remove prohibited features. It varies by region. Number 2, rifles based on common historical patterns. Semi-automatic rifles based on certain global designs. These are specifically restricted by name in most regions with hardware bans. Even models made domestically by local manufacturers fall under the ban if they have the prohibited features. Number 3, certain semi-automatic items with threaded barrels. A common mid-sized defensive item with a threaded barrel and the capacity to accept an accessory outside the primary grip could be classified as restricted in those states. A standard version of that same item without those features would be legal. This is why the features matter. Number 4, certain specialized defensive items. These are items built on popular athletic platforms, but with a stabilizing attachment instead of a stock and a barrel shorter than 16 inches. If they have a threaded barrel and other prohibited features, they can be classified as restricted hardware under state law. This is separate from the federal attachment issue. Number 5, certain semi-automatic smoothbore items. One popular imported model, for example. A semi-automatic smoothbore item with a detachable accessory and primary grip. Restricted in most regions with hardware bans. Number 6, a modern compact rifle firing specialized 5.7mm rounds, specifically named in some state bans. Number 7, a distinctive bullpup design rifle, named in some state bans and meets the feature test in others. Number 8, certain classic ranch-style rifle models. If this model has a folding stock and other features, it can meet the definition of restricted hardware, even though many people think of it as a traditional tool. These are just examples. The actual list of restricted items in each state is longer and more detailed. And this is the critical point. If you live in one of these states, you need to check your state's specific law. Not a video, not a forum post. The actual statute. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 owners who get accurate legal information without the hype. Subscribe now. Now, let me talk about accessory capacity restrictions because this is the other part of the hardware ban puzzle. 11 states and the capital have capacity limits: California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, Rhode Island, Vermont, and Washington. The limits vary. Some states ban accessories over 10 rounds. Some ban accessories over 15 rounds. One state limits most items to 15. Another limits long-form items to 10, but allows 15 for defensive handheld items. One major state restricts them to 10, but here's the complication. That same state previously tried a 7-round load limit. You could possess a 10-round accessory, but you could only load 7 rounds into it. Except that provision was struck down in court, so now the limit is 10 rounds and 10 loaded. This is why you need to know your state's specific rules. And here's what just happened in March 2026 that creates hope for owners. The Benson versus United States decision from the Regional Appeals Court struck down the capital's capacity ban. The court applied the established constitutional test. That's the High Court's 2022 decision regarding historical traditions. Under that test, regulations must be consistent with the nation's historical tradition of hardware regulation. The Benson court said, there's no historical tradition of banning accessories based on capacity. Accessories holding more than 10 rounds are in common use. There are tens of millions of them in circulation. Law-abiding citizens use them for lawful purposes, including self-defense, and the Constitution protects items in common use. Therefore, the ban is unconstitutional. This decision directly conflicts with other regional court decisions that upheld accessory bans. The Ninth Circuit upheld one Western state's ban in a prominent 2024 ruling. The Washington State High Court upheld its local ban in a 2025 case involving a local hardware distributor. When you have conflicting decisions from different regions, that's called a legal split. And legal splits are one of the main reasons the High Court takes a case. The High Court's job is to resolve conflicts in how lower courts interpret federal law and the Constitution. So the Benson decision increases the odds that the High Court will finally take up a capacity ban case. But it hasn't happened yet. As of now, capacity bans are still in effect in the states that have them, except the capital. And even in the capital, there may be appeals and further litigation. Now let's talk about what the High Court has said and hasn't said. A senior justice wrote a statement when the court declined to review the Maryland case in June 2025. He said the court should and presumably will address the modern sporting rifle issue soon, in the next term or two. That's not a ruling. That's a statement about future intent. Another senior justice dissented from the refusal to hear the case. He wrote, "I cannot see how these modern items fall outside the constitutional protection. I would not wait to decide whether the government can ban the most popular rifle in the country." But that official was the only one who issued that specific dissent. The other 5 majority officials did not join his statement. That tells you the court is not ready to take the case yet. They're waiting for the right case with the right legal record. Plus 1, quick legal note. This is educational information, not professional legal advice. Hardware laws change constantly. Always consult a qualified professional in your state for specific legal questions. So what does all this mean for you? First, if you live in a state with a hardware ban, that ban is still in effect. The laws have not changed because of any March 2026 High Court ruling. You need to comply with your regional law right now. Second, if you own items that might be considered restricted hardware, you need to know your state's specific definition. Don't assume. Check the statute. Check with a professional. Some states require formal registration. Some allow grandfathering. Some require modifications. Get it right. Third, if you're thinking about moving to a different state, understand that what's legal in one region might be a felony in another. A modern sporting rifle with a standard 30-round accessory is perfectly legal in Texas. It's a felony in New York if you don't comply with registration and capacity restrictions. Fourth, capacity restrictions are being challenged in court right now. The Benson decision is new. There will be more litigation. This area of law is in flux. Fifth, the High Court is likely to take up hardware bans and capacity bans in the next year or two. When they do, the decision will be based on the established historical tradition test. Expect the court to ask whether these bans are consistent with historical regulations. Expect them to focus on whether the items are in common use. And expect a decision that could change hardware laws nationwide. Let me give you the state-by-state breakdown right now so you know where you stand. One Western state, restricted hardware banned by features and by name, accessories over 10 rounds banned. One Northeastern state, restricted hardware banned by features and by name, accessories over 10 rounds banned, but older items grandfathered. Another Mid-Atlantic state, restricted hardware banned by features and by name, accessories over 17 rounds banned. A Pacific Island state, restricted hardware banned, accessories over 10 rounds banned. A Midwestern state, restricted hardware banned as of 2023, accessories over 10 for long-form items and 15 for handheld items banned, registration required. A coastal state, restricted hardware banned by name, accessories over 10 rounds banned. Another Northeastern state, restricted hardware banned by features and by name, accessories over 10 rounds banned. A neighboring state, restricted hardware banned, accessories over 10 rounds banned. A major Eastern state, restricted hardware banned by features, accessories over 10 rounds banned, Safety Act registration required. A Northwestern state, restricted hardware banned as of 2023, accessories over 10 rounds banned. The Capital District, restricted hardware banned, capacity ban struck down by a recent decision but may be appealed. Every other state, no statewide hardware ban. Some cities and counties may have local restrictions. Check local laws. Now, here's what most people get wrong. They think that because the High Court declined to hear the regional case, that means the court agrees hardware bans are constitutional. Wrong. Denying a review means nothing about the merits. The court denies review in thousands of cases every year. It doesn't mean they agree with the lower court. It just means they're not taking the case right now. The High Court has limited capacity. They take about 70 to 80 cases per year out of thousands of petitions. They pick cases based on multiple factors. Is there a legal split between regions? Is the issue nationally important? Is the legal record well developed? Is this the right case to resolve the issue? In June 2025, the court apparently decided the regional case wasn't the right vehicle. Maybe the record wasn't good enough. Maybe they wanted to wait for a legal split to develop. Maybe they wanted more lower court opinions to review. We don't know because the court doesn't explain why it denies review, but now we have the legal split. A recent ruling struck down a capacity ban. Other regions upheld capacity bans. That split makes it much more likely the court will take a case soon, and when they do, here's what's at stake. If the court rules that hardware bans are unconstitutional, all 10 state bans could fall. Millions of owners in restricted states would suddenly have access to items that were previously prohibited. The industry would see massive demand. If the court rules that hardware bans are constitutional, the restrictions stay in place and could even expand. More states might pass similar laws. The legislature might try to pass a national ban. The stakes could not be higher. Now let me tell you what to do right now if you're in a restricted state. First, know your state's law inside and out. Get a copy of the statute. Read it. Understand what's restricted and what's not. Second, if you own items that might be classified as restricted hardware, make sure you're in compliance. That might mean formal registration. That might mean physical modifications. That might mean storage in another region. Talk to a qualified professional. Third, do not assume that because you acquired the item legally in the past that you're automatically grandfathered. Some states require affirmative steps like registration. If you miss the deadline, you could be committing a serious violation. Fourth, be very careful about modifications. Adding a threaded barrel to a rifle that didn't have one could turn a legal item into an illegal restricted hardware if it meets the other feature requirements. Fifth, if you're buying a new piece of hardware in a restricted state, make sure it's compliant. Many manufacturers make versions specifically modified for restrictive regions. These have altered features to avoid the restricted hardware definition. Make sure you're buying the right version. Sixth, understand the accessory rules. Even if your item is legal, if you have accessories that exceed your state's capacity limit, you're breaking the law. Don't assume that because you can buy them online that they're legal in your state. Seventh, stay informed. This area of law is changing rapidly. Subscribe to channels like this one. Follow hardware rights organizations. Read court decisions. When the High Court finally rules, you need to know immediately. Eighth, get involved politically. Support organizations that are fighting these restrictions in court. Contact your legislators. Vote. The legal battle is important, but the political battle is just as critical. Now let me address the elephant in the room. What if you live in a non-restricted state and you're thinking, this doesn't affect me? Wrong. If you travel to a restricted state, even just driving through, you could be committing a serious violation if you have prohibited hardware in your vehicle. Federal law provides some protection under the Safe Passage Act of 1986. If you're traveling from one place where possession is legal to another place where possession is legal, and you're just passing through a restricted state, you should be protected. But you have to follow the rules. The item must be unloaded. It must be locked in a case. It must be in the trunk or somewhere not readily accessible. And you cannot stop for anything other than gas or bathroom breaks. If you stop overnight in the restricted state, you could lose the protection. This information could literally save you from a serious conviction. Subscribe now because next week I'm breaking down the exact historical test the High Court will use when they finally rule on hardware restrictions. Here's the bottom line. There was no March 2026 High Court ruling that made 8 types of hardware illegal. That headline is false. What actually happened is the High Court declined to hear hardware restriction cases in June 2025, allowing regional bans to remain in effect. In March 2026, the Regional Appeals Court struck down the capital's capacity ban in the Benson decision, creating a legal split. 10 states currently have hardware restrictions. The specific items that are restricted depend on each state's definition. Features matter, name models matter, accessory capacity matters. If you live in a restricted state, you must comply with the law right now. If you live in a non-restricted state, understand that traveling to restricted states with prohibited hardware can get you arrested. The High Court is likely to take up this issue in the next 1 to 2 years. When they do, the decision will be based on the established historical tradition test, and that decision could change hardware laws nationwide. Stay informed, stay compliant, and don't fall for clickbait headlines that spread misinformation. This channel exists to give you accurate, detailed, fact-based information about hardware laws. If this video helped you understand the truth about these restrictions, hit that subscribe button right now. Share this with other owners who need to know the facts. And remember, ignorance of the law is not a defense. Know your state's rules. Follow them. And stay tuned for the High Court decision that will eventually come. Legal disclaimer. This is educational content only, not professional legal advice. Hardware laws vary by state and change frequently. Always consult a qualified professional in your jurisdiction for legal questions. Stay safe and stay legal.